Hello everyone, this is Bry Labuanan and welcome to our third episode of our Obligations and Contracts series. In this video, we're going to talk about the different sources of obligations. So what are the sources of obligations? There are 5. According to Article 1157 of the Civil Code, obligations arise from law, contracts, quasi-contracts, delicts, and quasi-delicts. Since we have 5 sources of obligations, I decided to divide them among 3 parts. First part will be law and contracts, the second part will be quasi-contracts, and the third part would be delicts and quasi-delicts. So first, let us discuss law as a source of obligation. Sanchez Roman, a renowned lawyer and professor in the 19th and 20th century, defined law as a rule of conduct, just, obligatory, promulgated by the competent authority for the common good of a people or nation. It is a rule which must be followed because, as it is defined, it is deemed as obligatory. As Roman also defined the law is just, which means the law should be fair and only for the common benefit of all its members. But one characteristic that you should note is that it should be promulgated by competent authority, which in our case is our Congress. It does not only consist of congressmen or congresswomen, but also our senators. It is the legislative department, our law-making body. When there is no law promulgated, then there is no obligation that will arise. According to Article 1158 of the Civil Code, obligations derived from law are not presumed. Only those expressly determined under the Civil Code or special laws are demandable. Some of the examples of obligations derived from law are taxes, which is from our National Internal Revenue Code or our tax code. Also, we have the obligation for husband and wives under the Family Code to live together and observe mutual love, respect, and fidelity, and render mutual help and support. Also, we have in our Labor Code the obligation of employers to establish and maintain a safe and healthy workplace to their employees. So basically, only those expressly stated under our laws give rise to an obligation derived from law. Because again, obligations from our laws are not presumed. So the second source of obligation is contracts. We'll discuss contracts more thoroughly in our next episodes, but for now, we'll discuss contracts as a source of obligation. The definition of a contract can be found in Article 1305 of the Civil Code. It defined contract as a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. It is basically an agreement between the parties as to what conduct that they should perform, whether they should give, to do, or not to do something for each other. Now you may observe that only obligations to give and to do are mentioned in the definition of a contract. But it is submitted that obligations not to do may also be included in a contract, which usually does happen. Because it is basically an agreement, the parties are free to stipulate anything to be included in a contract, as long as it is legal. According to Article 1159 of the Civil Code, obligations arising from contracts have the force of law between the contracting parties and should be complied with in good faith. Meaning, although the obligation is not derived from law, because it is just an agreement between the parties, it is still be considered as having the same effect as those obligations derived from law. Just like any other civil obligation, the creditor may seek relief from the courts in case of non-performance by the debtor. Again, as stated in Article 1159, it should be complied with in good faith, meaning it should be done with full sincerity and integrity. Some examples for obligations arising from contracts are your obligations in a contract of sale, contract of lease, contract of employment, and your utang, your contract of loan. So again, your obligations derived from contracts have the same effect as those obligations derived from law. You can freely stipulate the things to be included in a contract as long as it is legal. So that's it for this video. I hope you learned something and I hope you understood 2 of the 5 sources of obligations, which is law and contracts. And please don't forget to click that like and subscribe button, because in our next episodes, we're going to discuss quasi-contracts, delicts, and quasi-delicts. So see you there.